Call this meeting the Judiciary Committee to order. Chair recognizes a quorum. Members, take your seats. Today we have 4 bills. We've got the procedural motion on House File 1138. We've got House File 4100, Representative Mahoney, Representative Moller's House File 3603, and we've got the pending referral on the COVID-19 Emergency Public Health Bill, which I think, as I understand this, we don't have, so we have to come back 15 minutes after session to take it up so that we get the committee report. But first, minutes of March 10th, 2020. Anyone review the March 10th minutes?
I did, Mr. Chair, and I make a motion to move them.
Thank you. The minutes are moved. Any discussion? Representative Cantrell's motion. Seeing none, all in favor say aye. Aye. All opposed say no. Motion passes. The minutes are adopted. The next bill that we got up, 1, 2, 3, 4. Well, it's 4-4, so I'm not going to take up a bill I might have the votes on.
Let's have some fun.
I bet you will. Well, let's take up. Are you guys going to cause me problems on Mahoney's?
Well, we just came from a really robust conversation.
I know you did. Oh, yeah, you're going to cause me problems on Mahoney's. Yeah.
Mr. Chair,
Yes, Chair Scott.
we could take up Representative Moller's bill.
Yeah, that's a good idea. You ready, Representative Moller?
This isn't a trick, is it? I just know that Mr. Chair, I just think it'll probably be a longer discussion on yours, just to kind of explain what you got going here, so.
That's fair. That's fair. Next bill, House File 3603, Uniform Canadian Domestic Violence Reciprocity Act. Representative Moller moves House File 3603 that it be placed on the general register. And you have an A1 amendment?
That's
Representative
correct,
Moller?
Mr. Chair.
Okay. Does anyone have the amendment? Any discussion? All in favor of the A1 amendment signify by saying aye. Aye. All opposed say no. Motion passes. The A1 is amended. Representative Moller, to your bill as amended.
Thank you, Mr. Chair and members. So this is the Uniform Law Commissions Act to recognize Canadian orders for protection. And just a quick note on the amendment. The amendment really puts the law consistent with what Minnesota law's language is. Mr. Johnson put that together and spent a lot of time going through and making sure that, like, the terminology and some of the process involved in the bill is consistent with our state statutes, and I understand he's out today, but I do really appreciate all the work that he put into drafting that amendment. And I will turn this over to my testifiers, but just note that Minnesota recognizes orders for protections from other states, and Canada recognizes United States orders for protection. And I can let the testifiers here give a little more detail about what this bill does.
Excellent. Thank you. Welcome back, Ms. Timmons. Please introduce yourself for the record.
Yes, Mr. Chairman and members, I'm Michelle Timmons, here before you as a Uniform Law Commissioner, and some of you may recognize me as the former reviser of statutes. House File 3603, with the author's amendment, will be the Uniform Recognition and Enforcement of Canadian Orders for Protection Act. As Representative Moller already said, Minnesota already recognizes these types of domestic violence protection orders from other states, and the act would expand the reciprocity to Canada. The act itself is short and straightforward. It really literally has 4 substantive provisions. Section 3 states that a state law enforcement officer, upon finding probable cause that a valid order has been violated, must enforce the terms of the Canadian order. Section 4 gives permissive authority for a court to enforce the terms of a Canadian order. Section 5 gives permissive authority to register a Canadian order but does not require it. And then Section 6 gives immunity to law enforcement officers and other governmental agencies, prosecuting attorneys, clerks of court, who are protected from civil or criminal liability for good faith enforcement of these Canadian orders. So it's pretty short and straightforward. I would note that it is an act that's a collaboration between the Uniform Law Commission and the Uniform Law Conference of Canada. It was worked out during the time that Commissioner and Judge Harriet Lansing was president of the Uniform Law Commission in the United States, has been enacted in Canada, in the provinces of Manitoba, Saskatchewan, British Columbia, and Quebec. And it's been enacted in 6 states, including our neighbors, North Dakota and Wisconsin. And this year it's been introduced in Vermont this year, as well as Minnesota. Since the act was worked out under Judge Lansing's leadership, I'd like to ask her to say a few words.
Welcome. Welcome to the committee, Ms. Lansing.
Thank you very much, Chairman Lesh and members of the committee. Minnesota, as we know, has consistently been a leader in drafting and enacting legislation for protection from domestic violence. And there are people in this room and who are here this morning who have done a lot of work on that, and I want to recognize and salute their work. A study conducted by the Permanent Bureau of the Hague Conference concluded that high levels of domestic violence and increasing cross-border mobility have made it clear that mechanisms are needed to enforce protection in cross-border circumstances. This conclusion is consistent with reports from a North American Leaders Summit that found high levels of domestic violence across Canada, Mexico, and the United States that warrants increasing attention and coordination on the enforcement of domestic violence protection orders. House File 3603 provides for the recognition and enforcement of Canadian orders for protection and strengthens Minnesota's existing web of protection against domestic violence, and I thank you for considering this act this morning.
Thank you. Thank you for your testimony, Ms. Lansing. Go ahead, Ms. Timmons.
Yes, Michelle Timmons again. Mr. Chairman and members, we have 2 advocates here who are able to provide support for the act. And immediately to my right is Katie Kramer from Violence Free Minnesota.
Thank you. Please introduce yourself, Ms. Kramer.
Hi, Chair Lesh, members of the committee. My name is Katie Kramer. I'm the Policy Director for Violence Free Minnesota, the Coalition to End Relationship Abuse, formerly the Minnesota Coalition for Battered Women. After 40 years as the Minnesota Coalition for Battered Women, it was time for us to update our name to reflect the vision that we work for every day of Violence Free Minnesota. We remain the statewide coalition with 90 member programs who provide advocacy and services to domestic and sexual violence victim survivors in all of Minnesota's 87 counties. I'm testifying today in support of House File 3603, permitting Minnesota to recognize Canadian orders for protection. Victim survivors who come to Minnesota from Canada to travel, work, attend school, visit family, or relocate for their safety or for any other reason should expect that their protection orders will be enforced in all jurisdictions on either side of the border. An example of this need is a woman from a Canadian reserve who had a Canadian protective order. She came to Brainerd, Minnesota, and her abuser followed suit. Out of fear for her safety, she ended up in a domestic violence shelter. Because she came from the reserve, she was able to cross the border with just her tribal ID. In order to get an order for protection for the woman in Minnesota, the shelter had to secure an additional identification from Canada and then get a Minnesota protective order, resulting in delays, risk to her safety, and the experience of additional trauma. Had this law been in place, it would have streamlined this process for the victim. The woman in this example was fortunate in that she had connected with an advocacy program that could help her navigate these matters. For a victim who is here in Minnesota with a Canadian protective order, whose perpetrator follows her, who is afraid for her safety, that victim should be able to call law enforcement directly without a concern that Minnesota won't recognize Canadian orders for protection. Full faith and credit when a court in any jurisdiction will honor and enforce orders issued by courts in other jurisdictions is not a new concept. The Federal Violence Against Women Act, or VAWA, enacted in 1994, gave protection orders the benefit of interjurisdictional enforcement through its full faith and credit provisions so that a valid order for protection may be enforced where it's issued and in all 50 states, tribal lands, the District of Columbia, and U.S. territories. VAWA's full faith and credit provisions protect survivors' freedom of movement by requiring law enforcement and the courts to enforce protection orders throughout the country. We believe this legislation will help ensure survivor safety and offender accountability on either side of the border. Thank you.
Thank you, Ms. Kramer, for your testimony. And you have another testifier as well, Ms. Moller?
That's correct, Mr. Chair.
Welcome. Come on down to the table. Please introduce yourself for the record.
Thank you, Mr. Chair and members of the committee. My name is Cheryl Thomas, and I am the Executive Director of Global Rights for Women. We are a locally based organization in Minneapolis. Most of our work is done at the invitation of partners around the world who are working to end violence against women through legal reform and systemic and social change. We draw on the powerful history and legacy of Minnesota on ending violence against women. You may know that Minnesota was one of the first states in the world to enact an order for protection law in 1979, just right after Minnesota or Massachusetts and Pennsylvania. It created the Duluth model of coordinated community response. It had the first shelter in St. Paul in 1972. All of these strategies and remedies for victims of violence are being replicated now around the world. In fact, just recently, the World Future Council gave the Duluth model of coordinated community response an international award for the best policy in addressing violence against women. The order for protection law that we have here in Minnesota has been a core reference point over the last 20 to 30 years with other countries who are drafting their first laws to end violence against women. And I think not very many people know that, and it's a wonderful example of our leadership. I think with House File 603, Minnesota has an opportunity to continue this powerful legacy as a role model in the global effort to end violence against women. I provided a little sheet of statistics there. I'll just name off a few of those. The World Health Organization states that 35% of women worldwide have experienced physical violence, and 30% of women who have been in a relationship report that they've had experience of some form or physical of sexual violence by their intimate partner. A really important report recently released by the United Nations Office of Drugs and Crime found that 50,000 women around the world are killed every year by family members, mostly intimate partners. That's 137 women per day. So when we think about global pandemics, and that's exactly what the United Nations and the head of the World Bank and the World Health Organization and many other global leaders now are calling violence against women and girls, is a global pandemic. I would just reiterate to close what Judge Lansing said, and that is that policymakers worldwide are embracing the need for cross-border collaboration and cooperation to end violence against women. An example is the European Protection Order, which allows persons to benefit from a protection order issued in one member state of the European Union to be recognized and enforced in other states. This remedy, this order for protection, as Katie stated and Judge Lansing stated, is one of the most effective and important remedies for victims of violence. And Minnesota here has the opportunity to really embrace that and continue that leadership. Thank you very much, Chair and members.
Thank you for your testimony, Ms. Thomas. Ripson Moller, do you have any other testifiers today?
I don't, Mr. Chair.
Is there anyone else from the audience who wishes to be heard on House File 3603 as amended, please raise your hand. I see no one from the audience. We'll move to member questions. Chair Scott.
Thank you, Mr. Chair. And thank you, Representative Moller, for bringing this bill. I do have a few questions, and I think this bill kind of begs the question, are there other foreign laws that we enforce here in Minnesota? And maybe that's a question for Ms. Timmons, I'm not sure, but, and if we do have other foreign laws that we kind of enforce, what are the nature of those? Are they mostly all safety related, if you know the answer to that?
Ms. Timmons, Judge Lansing. Got it, please call out.
The Uniform Laws Commission does have an international component where we're working with other countries for crafting and enacting laws reciprocally on a sort of one-on-one basis rather than through a full treaty that we sign, which then we go more into the federal legal structure on that. So we have a number of things that the Uniform Law Commission has done, and I was trying to think of one. I know that there are safety ones, and if Michelle and I just think hard about this, we'll be able to come up with one. We are working on one for that will be here next year that will have to do with healthcare directives, so that if you're in Canada or some other country, that you can have your healthcare directive recognized and enforced if you become ill. And Canada is very interested in that. We meet with Canada on a regular basis to work out what we call harmonized laws, so that we can have laws that are quite similar, that will be easy to refer to and for people to seek enforcement of. I also, in my capacity with the Uniform Law Commission, am a fellow for the European Law Institute, and I've been working with them on digital safety and privacy issues, so we tend to try to get our laws to mirror each other. But I'm sure that we can come up with a couple of others and forward them to you.
Chair Scott.
Mr. Chair, thank you. Is there any negotiations or talking with Mexico right now? I know one of the testifiers mentioned the Canada, America, Mexico collaboration, I guess, for lack of a better word. So on this particular issue, is there any thing going on there with Mexico?
That's a very good question. The Uniform Law Commission does have representatives from Mexico, and historically we have worked with them. We worked with them on nonprofit entities in trying to get some reciprocity on that, and they were very involved in it. We have had some difficulty in the last couple of years maintaining strong connection with them, but we continue to work on it. And Mexico is indeed one of the areas where we would like to get reciprocity. It's extremely valuable to have those systems in place so that we don't have some of the situations that Katie referred to where people don't have immediate access to safety issues. And Mexico would be a place that we need to work. Sometimes things move slowly, but you're asking these questions encourage us to keep on working so we can bring back some additional action in a place where we really need it.
Thank you.
Representative O'Neill.
Thank you, Mr. Chair. And I'm second author on this. Thank you, Representative Moller, for bringing this forward. It's a very important bill. Something that you and I had talked about as we were looking through the language is we were wondering, and maybe you talked about this already. I had some disruption a couple times you're coming in, so I apologize if I missed it. But can you just sort of walk through the steps of if a woman has this order but maybe doesn't have the paperwork anymore, is there any access to the Canadian database, like we have HRO and OFP databases now that all law enforcement can access? Thank goodness, it's been a while coming. And just wondering if there's that reciprocity where we can do that, or how does that functionally work? If someone, do they have to have the physical paper, or is there an access?
Representative Moller.
Yep, Mr. Chair and Representative O'Neill. So If there is a registered Canadian protection order, the BCA tells us that they can get that information through data pass from the judicial branch, so that information would be available. If there isn't that level of registration, then this allows probable cause determinations by law enforcement. And so I believe that would allow, law enforcement, it wouldn't have to be a registered order for protection. They could make some phone calls. They could look up other databases that the victim might be able to point to. And I don't know if my testifiers want to add. They're nodding their head yes. But is there anything I'm missing here that you want to add?
Ms. Timmons? No? Okay.
Mr. Chairman and Representative O'Neill, I think the issue of access to databases is something we could maybe work on through the Uniform Law Commission. It's a good question. But in general, yes, the probable cause determination and the flexibility that that gives the law enforcement officer is the answer.
Ms. O'Neill?
Thank you, Mr. Chair. One of those important details, if law enforcement rolls up on a scene and they say, well, I have a protection order, but there's no documentation, that puts them in kind of an awkward place, which is not unlike what we've had law enforcement do for quite some time with HROs. And, that just went live a month ago, to have that accessible to all law enforcement before they're served. So just a question, as I've had to muddy through some of those waters for the last 10 years to try to figure those things out. Really important, the connection to databases so law enforcement can quickly and easily ascertain what's happening. Also, I was wondering, are there other states around us that have a similar relationship with Canada?
Ms. Timmons?
Yes, Mr. Chairman, Representative O'Neill and members. Yes, North Dakota and Wisconsin already have enacted the Uniform Act. And the other states that have enacted it include Washington State, California, Nevada, and Delaware. It's been introduced in Vermont this year as well as Minnesota.
Thank you, Mr. Chair. Good to hear we're moving in the right direction.
Chair Considine?
Thank you, Mr. Chair. Actually, Representative O'Neill's question about verification rapidly was one of my questions that I think is key to this. And you may have already addressed this when I did walk in a minute. Does Canada enforce ours?
Ms. Timmons?
Yes. The provinces of Manitoba, which is right to the north of us, as well as Saskatchewan and British Columbia, enforce our OFPs already, as does Quebec, which has more of a French-style civil code system, but they have a provision that enforces it. And then Peter Lown, the head of the Uniform Law Commission of Canada, assures us that their ULC equivalent is making this act a top priority for enforcement for the remainder of the Canadian provinces this year.
Judge Lane?
Mr. Chair and members of the committee, just to add to what Michelle has said, when we drafted the law as representatives of Minnesota for the Uniform Law Commission, we sat down at the table and had the Canadian representatives from each of the provinces participate with us. And Peter Lown, who's from, as Michelle said, the Uniform Law Conference of Canada. It was it's an inspiring exchange to see that we can work together somewhat, off the direct governmental corridor and then bring it into the places where it needs to be enacted, and that we can keep moving toward getting it done on a sort of harmonization basis. But they've been very, very helpful. They come to our Uniform Law Conference meetings. We're having our annual meeting in Madison this year, and the Canadians will be there. And they actually patterned their Uniform Law Commission after ours, and we just attended their 100th anniversary of being in existence. The Uniform Law Commission of the United States has been around since 1892, so it's nice to see. And now the European Law Institute is trying to pattern what has been done by the states in the EU as well. So it's been a very exhilarating thing to see that safety measures can be put in place through this cooperative working with Canada.
Thank you, Mr. Chair.
Chair Johnson?
Chair Lesh, Ms. Timmons, always great to see you again. I've enjoyed working with you over the years. Judge Lansing, thank you for the work you're doing. Representative Moller, thank you for bringing this forward. This is something that does need to be done, but I want to make sure that it's workable. I see there's, in the bill, you have provisions to protect the officers as long as they're acting in good faith. But I'm want to make sure we have the process down right. We have people in here that have either prosecuted or defended people that these charges up for violations in this room, but I'm probably the only person that's actually had to serve the papers and actually enforce the orders. My concern is that if we don't have access to the actual paper, it's hard to act in good faith. When we're at a scene, whether it's the papers are from a different state or even different area of the county or the country or the state or a different area of the country, we either have our dispatch get copies of it, whether it was through email or a fax, so we could actually read those papers. Because sometimes there's exclusions in those papers for the individual where they can sometimes be together dealing with issues. And we've had people call in the violation, but because of the exclusion, it was not a violation. So it's important for the officer or somebody working with that to actually physically read the paperwork. So I'm glad this is moving forward, but we need to figure out a way to make sure that the officer on the scene or somebody that he has contact with can actually have physical copies of that so they can make sure that they can act in good faith and not get into trouble with lawsuits and stuff. You can write the immunity into the law, but somebody still files the lawsuits and it still costs a lot of money, and sometimes, even in good faith, the officer gets in trouble.
Representative Robinson.
Thank you, Mr. Chair. Thank you, Representative Moller, for bringing this bill and to your testifiers. This is an issue that's certainly very important to me and my community. We've tragically had a domestic violence death in Maple Grove very recently. Very important. My husband used to volunteer as an attorney young in his career for volunteering to support domestic violence victims. This is something my family's been very well aware of. So I just have two questions. One, Chair Johnson covered a lot of the concerns I have, but the difference between what you say is enforceable about whether it's expired, who the order is, what the due process rights are, versus then just granting best faith, good faith estimate of whether this is actually there really is troublesome to me. And I think having some requirement, it doesn't have to be a certified copy of the order, but some, a photo of the order or some documentation of the order, I think is so important for the protection of civil rights and for our law enforcement. So I would just encourage you to continue to push for records access at some level. And I agree it doesn't have to be certified, but just somewhere to start to verify this is a real thing is very important. And then secondly, I just wondered, in the other states that have this reciprocity or enforce the Canadian orders right now, you listed Wisconsin, North Dakota, is that just a relationship with Canada, or does that include other countries as well? Thank you.
Ms. Timmons.
Mr. Chairman, Representative, my understanding is that it is just with Canada to start. But yes, certainly the Uniform Law Commission is working with Mexico and has interest in expanding that further.
Thank you. Seeing no other questions, I would say that, Canada's system still comes from the common law, which is based on many of the same civil rights that we have. So I would presume that if there were a proposal from the Uniform Law Commission, it would take that into consideration if we were going to form these relationships, whether under VAWA or something else, that made sure that we protected the same civil rights in those documents to be recognized, which can be confusing. There are a few times that I've received phone calls from Canadian law firms asking if I could represent a client of theirs in St. Paul, because that's where I was, and they were actually meaning St. Paul, the suburb of Winnipeg, Manitoba. And I get these documents with a little crown on the top and everything, and it just looks kind of like Greek to me. So I want to make sure that police officers can understand whatever it is that they're getting on these as well. Seeing no other comments, committee discussion having been concluded, and no other testifiers from the public, Chair Moller's motion is that House File 3603 as amended be placed on the general register. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. House File 3603 as amended is placed on the general register. Thank you, Representative Moller, and to all the testifiers for being here. We are going to go in reverse order, and I'm going to, I apologize, Representative Fischer, but I'm going to make you wait again because we have a chair here and a commissioner here. And so they're going to go first. So Chair Mahoney, come on up. And
Mike here.
I move that House File 4100 be recommended to be re-referred to the Jobs and Economic Development Finance Division. I see no amendments, so Chair Mahoney, tell us about your bill.
Thank you, Mr. Chair and committee members. This is a bill that I'm doing because I have two daughters. And women in this world get 20%, or I'm sorry, 80%, paid 80% of what a man gets paid. It's absolutely ridiculous when they're doing the same amount of work. You all know that I'm a pipe fitter. If a woman is working with me on a job site, she gets the same amount of money, same benefits, same everything. That's the way it should always be. If they're doing the same work, there should not be any pay gap. And one of the reasons that pay gap exists is that the HR or the hiring person can ask without any problems, how much did you make at your old job? And if you don't answer, you're not going to get the job. Or if you do answer, you're likely to get 20, 30% less. Totally unfair, particularly in this world where we have, unfortunately, we have a lot of single mothers that are not getting any other support. They need the same that us old white guys get. So with that, that's what this bill does. It requires the, I could go into it a lot. I probably would be better off letting, after my last committee, I'd be better off allowing the, my testifiers to take over from here.
Excellent. Thank you. Welcome to the committee. Commissioner, are you going to go first, or how are we going to do this?
Chairman Lesh and members of the committee, thank you for inviting me. My name is Jill Hasday. I'm a distinguished McKnight University professor and the Centennial Professor of Law at the University of Minnesota Law School. I teach sex discrimination law and constitutional law, among other subjects. In my time today, I would like to make one simple but fundamental point. Asking about pay history perpetuates pay discrimination. I'll start with some historical background before describing the current state of the law. Before 1963, it was perfectly legal for employers to pay women less. This type of discrimination was pervasive and out in the open. Newspaper help wanted ads would list one salary available to men and a lower salary available to women doing the same work. Many hoped that the Federal Equal Pay Act of 1963 would end pay discrimination between men and women. But 57 years after the law's enactment, an enormous wage differential persists. The median earnings for a woman working full-time and year-round in 2018 were just 81.6% of the median earnings for a male worker working full-time and year-round. The latest studies estimate that America's wage gap will not close for white women until 2055, for black women until 2130, and for Hispanic women until 2224. One important reason for this persistent wage gap is that employers frequently ask job applicants about their pay history before deciding what salary to offer. This widespread practice means that workers often cannot escape pay discrimination by seeking a new job. If a woman is paid less at one company, perhaps because her boss simply assumes that women deserve less, the consequences can reverberate for a lifetime. Discrimination early in a career can lock someone into a permanent cycle of unequal pay. Unfortunately, federal law does not prohibit employers from asking job applicants about their pay history. Indeed, federal law accepts, even encourages the practice. Employers sued under the Federal Equal Pay Act for paying women less will commonly defend their unequal pay practices by contending that they set salaries relying on each job applicant's pay history. The United States Court of Appeals for the 8th Circuit, which covers Minnesota, has accepted this argument, holding that it does not violate federal law for an employer to pay women less if the employer determined pay scales by relying on pay history. I'll repeat that because it's important. Federal law does not stop employers from paying women less for doing the same job as a male employee, so long as the employer can point to pay history as the basis for the discrimination. The ability to rely on pay history provides employers with a ready-made excuse for underpaying women, but efforts to amend federal law to prohibit employers from asking about job history have so far been unsuccessful. A growing number of states and localities have responded to this problem by enacting their own laws that bar employers from asking job applicants about pay history. These laws are aimed at ending the cycle of pay discrimination so that everyone can receive equal pay for equal work. The laws benefit women and anyone else with a history of being underpaid. To date, approximately 18 states and 21 localities have prohibited employers from asking job applicants about pay history. Minnesota should join this reform movement. Every Minnesotan deserves equal pay for equal work. Thank you very much.
Thank you, Professor Hasday. Commissioner, welcome back to the committee.
Thank you. Good morning, everyone. Again, my name is Rebecca Lucero, and I'm the Commissioner for the Minnesota Department of Human Rights. I'm excited to speak with you today about this bill, House File 4100, which would ensure that employees are paid based on their experience, based on their skill, their track record, and responsibilities of the position, not on their salary history. When an employer makes salary decisions based on someone's salary history, it can continue the never-ending cycle of pay inequalities for women. Inequalities in pay perpetuate when further salaries are anchored to past salaries. That's why House File 4100 is an important step to closing the ever-persistent pay gap so that all Minnesotans can thrive. So these pay gaps are persistent and historical, as Professor Hasday talked about. A woman is so regularly paid less than a man with similar experience, qualifications, and seniority for the same job that we're compelled to ask, what practices or policies are perpetuating inequality in pay, resulting in this discriminatory outcome, even if there's no discriminatory intent? The pay gap is also so disparate. In 2018, women in Minnesota still earn approximately 80 cents to every dollar a man makes. For women of color, as was noted, that pay gap is substantially worse. Asian women earning 71 cents to the dollar, Black women earning 58 cents to the dollar, Native women 56 cents to the dollar, and Latinas 52 cents to every dollar a man makes. Given this, we are again compelled to ask what practices or procedures are perpetuating inequality in pay, resulting in this discriminatory outcome. So while there are many reasons for the pay gap, relying on an applicant's previous pay when setting the salary for a new job is one of these practices that often causes an inequality in pay by following women from job to job. That's why the pay history bill is so important. The pay history bill makes it clear that Minnesotans should be paid based on their experience, skills, track record, and responsibilities of the position. It would prohibit an employer from inquiring into, considering, or requiring the disclosure of one's salary history through the hiring and promotion process. When Minnesota passes this bill, it will be an important and proactive step in closing the pay gap. Minnesota will also join a groundswell of 18 states, including Missouri, Alabama, and North Carolina, that have already passed statutes to end pay history questions. As the state's civil rights enforcement agency, we're committed to ending discrimination so that every Minnesotan can live lives full of dignity and joy. I really look forward to working with all of you to move this forward. Be happy to answer any questions.
It's a great vote. It's a great bill. You should vote for it.
Any other testifiers from the public who wish to be heard on House File 4100? I don't see any hands going up the audience, but we have a question from Representative Cantrell.
Thank you, Mr. Chair. Thank you, Commissioner Professor and Chair Mahoney. I just really wanted to thank you for bringing this bill forward so that we can finally catch up to Alabama and equitable measures in our law. You know, low pay, as you mentioned, Professor, low pay at someone's last job under this current practice means that they're going to be paid low at their next job and at the job after that, and it ends up propagating a cycle of not only underpayment but undervaluing in the marketplace. I, in anticipation of this bill hearing, I was just doing a little bit of research into kind of the history of asking for folks to disclose, or asking for prospective employees to disclose salary. It's meant to determine someone's market value. And I think that is unfortunate because women, people of color, people with disabilities have been dramatically undervalued in our society as it is, and this is just one more way in which that devaluing rather is being propagated currently in our employment law. So I think in the interest of not only equity and prosperity, but in the interest of fairness, we need to pass this bill, and we needed to pass it yesterday. But let's go catch up to Alabama. Thank you, Chair Mahoney. Thank you, Chair Lesh.
Chair Considine.
Thank you, Chair Lesh. Were you able to identify other practices besides this that contribute to the pay gap? And if so, what were they?
Professor Hasday.
Thank you. The pay gap is an enormous problem, and I think many different strategies will have to be used. This is just one of them. For instance, courts, in my view, aren't vigilantly enforcing existing statutory prohibitions on employment discrimination. They're often reluctant to acknowledge evidence of outright bias. But I think this statute is one important step. It's not the only one, but it's an important step.
Thank you, Professor Hasday. Seeing no other comments from the, oh yeah, Representative Herb.
Thank you, Chair Lesh, and thank you, Representative Mahoney, for bringing this bill forward. It was really interesting. And so I don't know how many people know this, but I have been working on a doctorate for way too long. And part of my dissertation that I'm working on is really looking at women, specifically Southeast Asian women's, their corporate climb and the barriers that they face and the pay that they have. And I just wanted to point out that I completely agree with everything you all are saying, and I just wanted to add that for women to actually make, like Asian women in some categories, make the same as white men, but they have to have way more education and way more experience to get paid the same as a white man. And so this disparity carries on even after women get experience, after women have way more education, and that we continue to see this. And so this is just a small first step that we need to take in order to then look at all of the other disparities and how we can fix those as well. And I think that there will be ripple effects. So I appreciate this bill, and I think it's wonderful, and I hope that everyone supports it.
Chair Mahoney.
To Representative Herr, it's not just Asian women. It is all women that have to have more education and more experience and more and more and more. And that's not fair. The only place you don't find that is in the building trades.
Just a quick follow-up that, it's just, I was just referring to my particular dissertation, and so I just wanted to make sure I'm not making statements for all categories of women, just what my research told me about Southeast Asian women.
I'll move that House File 4100. Oh, what?
I had a question.
Chair Scott.
Thank you, Mr. Chair. My question, and I don't know to which testifier this goes to, but on the top of page 2, starting with 2.1 through 2.6, in my reading of that, I'm a little bit confused as to whether this language prohibits an employer from offering the same or a lower salary if the applicant offers their past pay history voluntarily.
Commissioner Lucero.
Chair Lesh, Representative Scott, thank you for this question. I find this to be a little bit confusing as well, and I think this is an area where I'd love to work with you offline to clarify this a little bit. Certainly the intention is to end pay discrimination, and so we want to make sure that that's really clear to get towards that.
Thank you, Mr. Chair. And so is the intention of the law to require, if the information is, past pay information is volunteered by the applicant, is the intent of the law to require the employer to pay at least what they were making before and/or more? Is that the intent of the law?
Chair Lesh, Representative Scott, thank you. No, that is not the intent of the law. This is really intended to be able to say to employers, look, there's a lot of ways that you might know somebody's salary. For instance, us public employers, our salaries are public. My salary was published in the Pioneer Press when I was appointed. And so if somebody knows about what my pay is, people know things. They also know my sex. They might know that I'm Chicana. They might know things about me, but it's there to say that that can't be the reason for making the decision. And so it's actually there to protect employers.
Mr. Chair?
Okay, Chair Scott.
Thank you. Just another question. On line 2.10, it lists there that there's a prohibition against discriminating based on membership or activity in a local commission. And I wondered what you had in mind there. Is that new language? Is that elsewhere in the human rights statute?
Commissioner Lucero?
Yeah, thank you, Chair. Yeah, that's directly from the human rights statute, and I can find where that is and point it to you following this.
Mr. Chair, thank you. I'd like to know more specifically what that means.
Sure.
And then, I'm trying to find it, I read it last night, but I thought it was saying that, like when the pay is public, like with a state employee or whatever, and the information can be found in public records, I think it must be on page 1 towards, I don't know, somewhere between 116 and 121.
Yep.
But I didn't see any information there about counties or local cities, because a lot of times their employees' pay information is also public, and it didn't seem like that was included in the language. Maybe I'm remembering that wrong from last night reading it, but it's not just state employees or federal employees where their pay information is public. It's beyond that. So thank you, Mr. Chair.
Chair Johnson?
Chair Lesh, Representative Mahoney, I was actually talking to a couple friends of mine last night. Both are women, and they actually have a problem with this bill, because when they were asked about their wage, when they were applying for a new job, they told them, granted they were looking for a work closer to home instead of driving down to the metro all the time. They actually told them their wage when they were asked. They ended up getting more money because they wanted them to work there. So if they went to ask their wage, they would have got paid less. So it works both ways, so we got to be careful to make sure we don't make things go backwards as well.
Representative Cantrell.
Thank you, Mr. Chair. I'd like to request roll call on this.
Roll call's been requested. Representative Robbins.
Thank you, Mr. Chair. Thank you, Chair Mahoney. Nice to see you. So I'm very sympathetic to what you're trying to do. As a woman in different phases of my career, I have had more education and more experience and been paid less than my predecessor, so I know this is a real thing. But there are also points in my career where, because I chose to step out of the workforce for 10 years and was probably less productive at the time when computers were getting online and I was a little behind the technology curve, I was less productive and I went back to work. I needed time to catch up. So I think there's a lot of variables in what goes into salary, and I appreciate, Commissioner, that you referenced that about experience and level of training and productivity. Productivity is the main driver of wages, and I just think we have to keep that in mind. So with that in mind, I would like to just question about the strength of this and what the penalty is. So in line 1.11, it says that the employer cannot even consider from any source pay history. And then if they do that, it's an unfair discriminatory employment practice. This is line 116 under section 36A, blah, blah, blah. Forgive the blah, blah, blahs. So just, I'm wondering, if you can't even consider pay history from any source. Like you said, yours is public. Like people, there's stuff in the ether you just know. And if the test is you can't consider that, that seems very onerous if there is a penalty. So could you address that, and could you address what the penalty is, please?
Well, I could have Professor Hasday answer that, because you spoke to that a little bit in terms of the litigation reasons for this.
Okay, I have a, thanks for your question. I think, a two-part answer. First, even controlling for factors like productivity, the wage gap remains largely unexplained. So one economic study controlled for race, region, unionization, education, occupation, work experience, 38% of the wage gap remained. So it's not an adequate account, all these other factors, though obviously that's something. The second thing is a bill to stop employers from asking about job history just does that, no more, no less. Employers would remain free to set pay scales according to the level of education required, the time commitment, the scarcity of the skills. In other words, there's still going to be people paid less and people paid more. It's just that it wouldn't be based on pay history. It would have to be based on the job itself rather than someone locked into a cycle of being consistently underpaid.
Okay. Representative Robbins?
Mr. Chair, thank you. And I agree with that, maybe not asking directly, but the fact that they cannot consider information that's out there just seems a little bit of a stretch too far for me.
Commissioner Lucero?
Chair Lesh, thank you for that. So there's a lot of things that an employer knows about somebody that they are not or are prohibited from asking about. So you, again, might know that I'm a woman. You might know that I'm a woman of color. You might know that I might be a pregnancy-bearing age. These are all factors that we have said, hey, we don't want employers to be considering these because this is adding to discriminatory outcomes. And so if somebody knows something, that's fine. You know all these things about me. It's what are you actually basing your decisions on? And employers can base their decisions on all sorts of factors that are around the job itself and not around who I am as a person or the cycles of discrimination that have persisted before me.
Thank you. Seeing no other questions before the committee, then, I don't see her, do you see her? Okay. Then the motion before the committee is to move House File 4100 to be re-referred to the Jobs and Economic Development Finance Division. All in favor signify by... Oh, yeah, roll call's been requested. Chair votes aye.
Representative Moller.
Yes.
Representative Scott.
Aye with reservation.
Representative Albright. Representative Barr.
No.
Representative Cantrell.
Yes.
Representative Carlson.
Yes.
Representative Considine.
Yes.
Representative Hassan.
Yes.
Representative Herr.
Yes.
Representative Johnson. Representative Liebling.
Yes.
Representative Lucero.
No.
Representative Mariani. Representative Noor.
Yes.
Representative O'Neill. Representative Robbins. Representative
Yes,
Zhang.
yes, but I look forward to seeing it in jobs.
Representative Zhang.
Yes.
Representative Albright.
Yes.
Representative Johnson.
Yes, with reservations.
Got 14 ayes, 2 nays, and a handful of ayes with reservations. I don't know how to count those, but the motion passes. The bill is referred to Jobs and Economic Development Finance Division.
Thank you, Mr. Chair. Thank you, committee members.
Thank you.
Thank you. Chair Lesh?
So, Representative Fischer, thank you very much for your patience. We do
Chair
appreciate it.
Lesh.
You were here from the beginning.
Chair Lesh,
Oh, right, okay.
Chair Lesh,
Chair Johnson.
Representative Mariani, or Representative Muller, or Mahoney. I'll get it right eventually. It's been a
We're
long
going
week.
to go through 134 before you got to them.
As this bill moves forward, if you could please consider the concerns that we have as we go forward and try to work on them.
So, members, this bill is a Rule 4.2? 4.20 hearing, which means we're just going to take this up. I'm not going to, I haven't heard anything else really substantive about if any deals. Where is Representative Fischer? Yeah, come on down. So we're not going to take any public testimony, and it was fully debated last year, so the intent is just to move this to the general register. Then there are no amendments.
There is a technical amendment,
There is.
Mr. Chair. It's to change the date from January 1st, 2020. The effective date would be January 1st, 2021.
Okay.
So moved.
The technical amendment has been moved by Chair Considine. All in favor of the technical amendment, it's A5, signify by saying aye. Aye. All opposed say no. Motion passes. The A5 is adopted. So it's our intent to just move this to the general register as stated. Any discussion? Seeing none, then the motion that the chair makes is that House File 1138 as amended be re-referred to the general register. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. The bill is as amended is re-referred to the general register.
Thank you, Mr.
Thank you
Chair.
for hanging around for such a short
You're welcome.
thing. If you want to say anything else, you can.
Just want to say thank you to the committee to keep it going. Appreciate it.
All right. Thank you.
Short and sweet.
Yeah. Okay, so, members, we are going to recess because we don't have possession of the bill, and we have to get it processed, so it's in our possession. But before that, Chair Liebling, do you have testimony on it? Do you want to present it, or?
Well,
got
Mr.
time
Chair,
now.
I think I could, if I could just present the bill right now, I
Yeah,
think
go
we
ahead.
could save time
Let's go do
later.
that. We're all about saving time here.
Thank you, Mr. Chair and members, for allowing this weird process we're in. I think everybody understands that with the COVID-19 issue, we're trying to move things very, very quickly, and also at the same time to really do this right. So I appreciate everybody's indulgence, and Representative Albright and I were just talking about this issue too, and he's, I know all of us have concerns about what we're going to do, how we're going to approach the issue, and I really appreciate all of the input. So House File 4327 is going to be before this committee
Your
later.
motion, Chair Liebling, your motion is that it be re-referred to the HHS Finance Division, your committee, and you have an
Yes.
author's amendment, the A4, is that right?
Yes, Mr.
Okay.
Chair, I do. And so, members, what's before us is actually a clone bill. So this will come back to HHS. It's really, the bill that you see in front of you has two pieces to it. Only one of them is really, I think, before this committee, and that is there are two pieces. One is an emergency powers piece, which I don't think there's anything that this committee, we can certainly talk about that if the chair chooses, but I think the reason it was here is because of this loan fund piece, which has a data provision in it. And there will be an amendment to that data provision. We've had some discussion about this, and Mr. Johnson, who's not here right now, has an amendment for me, and I think the amendment is kind of a, we'll bring this probably into a shape that members will be much happier with.
Thank you, Chair Liebling. I actually do have a couple of questions about the peacetime emergency provision.
Okay, happy to answer those.
Just because, I don't know, in law school, I did studies on the Commission on Public Safety that occurred during World War I and the influenza outbreak of 2018, the Spanish flu, which technically wasn't from Spain, it was from Kansas, but the soldiers that deployed to the front in World War I brought it to Spain, via Spain, and so they were the first reported cases, so it got called the Spanish flu. But there were some emergency powers that were enacted in Minnesota under the Commission on Public Safety that were, if anyone has read the research from Professor Hy Berman at the University of Minnesota, drastically implicated civil liberties in the state to measures that we would consider outrageous today. But if you can say, what does that mean in 12.31 that allows the governor to declare that peacetime emergency? What are the parameters and what are the implications for it?
So, Mr. Chair, I'm certainly not an expert on this. What we're doing in the bill is we're clarifying that a peacetime emergency includes a public health emergency. So if you notice in the current language, it says a peacetime declaration of emergency may be declared only when an act of nature, a technological failure, et cetera, I think it's pretty logical that an outbreak is an act of nature. And so, our contention is that it is. But in order to just be very clear that a public health emergency would be included within that, that's kind of what the bill is doing. And there's a definition then about what a public health emergency is, so that it isn't so broad that this can be used for just anything, that it has to be pretty serious. And you can read through on lines 1.10 through 1.21 what the definition is, and that language is taken from other places in statute where this is defined. So it's kind of not a new definition, but meant to constrain both make it clear that a public health emergency is included in an act of nature, but also to make sure it's not so broad, because the Chapter 12 powers are pretty extensive. So that's the first piece of this. The only thing that's a real change is, if you'll notice on lines 2.14 to 2.15, it's giving an exception that a public health emergency may be continued up to 90 days instead of 30 for other kinds of emergencies. And the reason for that is because the Department of Health feels that just because of the nature of a public health emergency, like a contagion, sort of the life cycle of it, it's likely to be a bit more of a trajectory than 30 days. So that's the idea here. And if you notice, too, these emergency powers are constrained. The governor doesn't just, there is some touching base with the legislature on this. It's not completely unconstrained to declare one of these. He can declare it for 5 days, and then the executive committee has to, I think if I remember this, executive committee has to do something, approve it, or it's here in the current language. I just didn't review this before coming here today.
And Chair Liebling, the reason I'm asking is, this is one of those situations where there's a risk heavily reported on in the media. There's nervousness about increase in deaths. There are global things on the news. Everything's happening, and there's a lot of pressure for us to move quickly on measures. And I get that, absolutely. I'm going to support it when the bill comes before us. But I just want to make sure I totally understand what we're doing, because there's so many items in here. Like I don't know what significant risk of substantial future harm really is. And I'm sure it's located elsewhere in statute, and there are probably examples of what that has been interpreted to mean by the courts, but I don't know if there's anyone here who could explain that to me. Maybe not.
Well, Mr. Chair, I don't think my testifiers weren't expecting me to be here presenting the bill this morning, so I don't think there's anybody here from the Department of Health. But, I think that by the nature of this, there's going to be always some discretion. I mean, that's kind of the nature of this thing. We will never be able to define completely, and that's why we've got here some safeguards. So a peacetime emergency must not be continued for more than 5 days unless extended by resolution of the Executive Council up to 30 days, except, now this is the added language, except that a public health emergency may be continued for up to 90 days. So that would be by action of the Executive Council, which is, I think, is the governor, the Secretary of State, I'm not sure who all. Again, this would be something maybe somebody from House Research would be more prepared to speak about, but it's not unconstrained authority. And the point was just that there was some concern that in this particular situation we're in, we're going to be out of session. The governor may have to, move resources around. He may have to waive certain rules and regulations to get resources and treatment and testing and things like that to where it needs to be in the state. And that's why we wanted to make it super clear that he does have emergency power that extends to this type of emergency.
Understood. Is this anything that research can speak to? I'm not going to put you on the spot, Ms. Mullen. I mean, if you can't. So the question was, is significant risk of substantial future harm to a large number of people, is that defined elsewhere in statute? And have the courts, I guess, interpreted or issued holdings on what significant risk to substantial future harm is anywhere?
Chair and members, that is not something I've looked into, but we can get you an answer and see if there's case law on that, if it has actually been litigated before.
Okay, that's fine. Do you happen to know, Chair Liebling, where else in statute this is taken from?
Mr. Chair, I think it might have been taken from the contingency account language. I'm not 100% certain about
That's
that,
fine.
though, and I don't have that with me either.
Other questions? Chair Johnson.
Chair Lesh, Representative Liebling, thank you for bringing this forward. I have some of the same concerns that Chair Lesh brought up. Last night, in your caucus as well as ours, we had the governor in talking about this issue. And one thing that he stressed is be careful how much power you give him, because to make sure that we don't overextend that power. So I just want to make sure that we do this right. It doesn't matter who the governor is. We have to make sure, our job is to make sure that his duties are in check and not grant too much authority, but we need the right amount of authority. So as I read this, I do have a few concerns on it, but I think we can work some of those out. Where they talk about pandemic, my question is, who's saying it's a pandemic? Is this Minnesota Health Department? Is it the federal health department? I think we need to clarify who can actually say it's a pandemic for these issues to come forward.
Thank you, Mr. Chair. And along the lines of what Chair Johnson was just speaking to, I'm not clear, Representative Liebling, with this extension to the 90 days. And then if you look at that 90-day, the extension to 90 days, and then paragraph B right below that, it says that after 30 days, if the Executive Council extends for 30 days, at the end of that, it looks like the legislature, if they want to extend it beyond that, should be consulted, and we would have to come in and give that continuing authority to the governor. And so my question is the 90 days continuous and the legislature wouldn't be called in until after 90 days? Or would they still be consulted and brought back in after 30? And we have a distinct role to play in all of this. There are three branches of government for a reason. And I look at the authorities in Chapter 12 given to the governor during an emergency like this. And one of the first ones is make, amend, and rescind the necessary orders and rules to carry out the provisions of this chapter and section. And it's very, very broad authority as far as spending money and as far as enacting. That he can call up the National Guard. There's a lot of things in that chapter that the governor can do. And regardless of who that governor might be, the legislature, I think our role is to provide a check and balance. So I don't know if you know the answer to that question, Representative Liebling. Is it a continuous 90 days without legislative input, or will we still be brought back in after the 30 days?
Chair Liebling.
Well, Mr. Chair, as you know, Representative Scott, I am not an expert on Chapter 12. This is existing authority except for the 90-day extension. I just want everyone to be really clear about that. And there's a reason that these are pretty extensive powers. And, I agree with Governor Walz. He told our caucus as well, you have to be careful that you don't upset the balance of power. I mean, we have seen a lot of upsetting of the balance of power lately, and it's not a good thing on the national level. So I think, but if you look at this, the way I read this, you've got well, first of all, let's just understand that in a real emergency, you need somebody to be able to make kind of really fast decisions to protect the public health and safety. I just think there's no way around that. And that's why, this chapter, I think, does constrain executive authority. Now, we may think overall that we need to do something in addition to change all of Chapter 12, like maybe as a body, we think the whole thing is too unconstrained. I don't know. But for purposes of this, we're not giving him additional authority. The only thing that's really changing here is the 90-day. So as I'm reading this, it says in, starting on 2.18, the legislature may terminate a peacetime emergency extending beyond 30 days. Now, I don't know how we do that if we're not in session, but that's Chapter 12. I mean, maybe we need to figure that one out. I'm certainly open to that if anybody, wants to try to do that. But I guess I'm not really seeing that. This is the Executive Council, it's up to 90 days. I'm not really sure what happens. Oh, there we go. I'm sorry. Actually, maybe Ms. Clark-Fisk could come and help me because she's been, with House Research, she's been working on this. Thank you for coming down.
Okay, so, please introduce yourself for the record.
Mr. Chair and members, just to answer that question, if the legislature is not in session and...
Please introduce yourself for the record.
Sorry. Mr. Chair and members, I'm Elizabeth Clark-Fisk from House Research, and to answer that question, if the legislature is not sitting and a peacetime emergency is extended for more than 30 days, the governor has to call the legislature into session. That's in paragraph B.
So it was Ms. Clarvis?
Clark-Fisk.
Clark-Fisk, thank you.
Yep, sorry.
Okay, Chair Scott.
Thank you, Mr. Chair. And so I'm not sure why we have the 90 days then. If they're going to come back and consult the legislature after 30 and say yay or nay as far as can you continue this public health emergency, what if the legislature says no? Does that override the 90-day extension?
Ms. Clark-Fisk, or Chair Liebling?
Thank you, Mr. Chair. Representative Scott, as so often, I think you've identified a real missing piece here, and I appreciate that. That's why we have these hearings, right? And I think we do need to kind of think about, right? That's how I think we need to think about that. I just think we didn't, think that piece through. So I think you're right. The other piece, of course, is that if it's a pandemic, we may not want to reconvene, and we need to find some way. Well, then, of course, there's an issue of what if we need another 90 days? So I think there are some things to think about here for sure. And if you have thoughts about that, I think this bill now, this piece, now I'm reminding everyone, what's here is a clone. And there are actually two separate bills moving, and the one that has this is now in Ways and Means. But we can certainly amend it. And, these things are moving really fast. And as I've said many times in this process, I really appreciate many eyes being on this because we really do need to get this right. So thank you.
Chair Scott?
Yeah, thank you, Mr. Chair, and thank you, Chair Liebling. And I didn't bring this up to be political in any way. I was unclear on what the language was really saying. And I do know that there was probably a reason for that 30-day limitation initially, and that was probably to keep the separation of powers in check. And so I just want to make sure that we get this right moving forward, and I thank you for your comments.
And in light of that, Chair Scott, and we'll get Representative Robbins next, I want to make sure people understand that this is actually the job that we were elected to do here, okay? I mean, a lot of times, Everyone does their homework ahead of time. Bills come in presented as a fait accompli. It's been heavily vetted by interest groups and everything, or we have Peace in the Valley or something, and so there's minimal questions to be asked, and those questions that are asked are like this. Well, when you got a pandemic, okay, this is where you make your money, okay, your per diem, okay? You review the language and figure it out, because this is actually how they did it in the old days and how we're supposed to do it. So I particularly appreciate the questioning by anyone, so we make sure we can get it right, and I know Chair Liebling appreciates it as well. Representative Robbins.
Thank you, Mr. Chair. Thank you, Chair Liebling. I really do appreciate your leadership on this and the governor's leadership on this, and we all do really want to be partners in getting it right. And I had similar questions to Chair Scott and Chair Johnson, so I'll let you just continue to deal with that. I would say the other two questions I had were regarding on 1.12, where it says pandemic influenza or an outbreak of a communicable or infectious disease. I would just like some sort of qualifier on that, because any outbreak of any communicable or infectious disease seems low to me, unless pandemic is modifying those as well, but it doesn't seem to be. So I would just like you to take a look at that. And then secondly, because this is new territory for all of us, and this is of great concern for the powers we will be giving any future governor, my personal interest would be maybe in doing a very tight bill that says for the next calendar year until the next legislature convenes, we give the governor these powers or whatever, but these powers regarding public health emergency will expire, at whatever date, January 2021, so that we have a chance to see how it worked and see what else is in there. I don't know that we need to give him unlimited power, or all future governors this public health emergency unlimited powers. I think we could set some sort of a expiration date on just that public health emergency part of it, and then reevaluate. And I think that would serve future governors and future legislatures well.
Chair Liebling.
Mr. Chair, thank you. Representative Robbins, I guess what I would say to that is that when the legislature comes back in session, we can always change and reevaluate. And I'm pretty sure that with the things that we're doing right now to try to deal with the COVID-19 issue, that we're going to have to be reevaluating when we come back, both these kinds of things and the money pieces and a lot of stuff. I mean, we're going to learn and change from this emergency. So I would really be reluctant to put a sunset on these kinds of powers, because you just don't know. If you sunset these powers, first of all, I want to emphasize again, we view this as a clarification of existing law other than the 90-day piece, right? So if we were to sunset this, I think we'd be saying to a future court, we really don't think this is part of current law. And then if there's an emergency in the meantime and the thing is needed, we'd be in deep trouble. So I really would be reluctant to do it that way. The other piece to your first part of your question, this section has to be read together. So it's an infectious pandemic influenza or an outbreak of a communicable or infectious disease and then you've got the 1, 2, 3, 4. So it's, I think it is, maybe Ms. Clark-Fisk can speak to it, but I would say that that is constrained exactly as I think your concern is exactly met in the language. But Ms. Clark-Fisk, do you want to comment on that piece?
Mr. Chair and Representative Robbins, I would say that the clauses following, starting on line 1.13, those qualify communicable or infectious disease, so that the disease has to meet at least one of those criteria.
Representative Robbins.
Thank you, Mr. Chair. Thank you, Chair Liebling and your testifier. I'm just concerned that it's not, it's fairly broad if only one of those tests has to be met for a communicable or infectious disease. And to the other point, I was just suggesting a sunset on the public health emergency part of the emergency powers, not all the existing law. Thank you.
And Mr. Chair, Representative Robbins, I understood that. I'm just saying for the emergency part, when you try to clarify something, I think the risk you sometimes run is that if you don't actually clarify it, then the court might think that it wasn't in there to begin with. And I'm worried about that. So if we're saying this is something that's going to sunset, then we're saying it's not really a clarification, it's a new power. And it's not a new power. I believe this is already there, other than the 90-day. Okay? So that's why I'm saying I would be very reluctant to put a sunset on this and then have it be expire, and then somebody says, oh, now you don't have that power. And then we have an emergency that requires this kind of emergency. So I just think that complicates it unnecessarily, perhaps, who knows? But, you know, again, when the legislature's in session, we can, if it's turned out to be not workable or too broad or something, we can always address it at that point.
We have Chair Johnson, Cantrell, O'Neill, Barr, Albright, Scott. We have 6 minutes left. We are going to recess and reconvene after 6 minutes. But what would be really super cool is if folks could get some of the questions that they have asked between now and when we reconvene. What? Well, I'm going to go to, you're on the list.
I want to, before we get to break today,
Okay. Go
Mr.
ahead.
Chair, my question is with a clone bill, so there's two bills moving, or the amendment process and how we match everything up. It's a procedural question, so
Okay.
I'm just asking so we can work this afternoon, how do we approach this?
Well, if you had questions about the bill, you can address them to this one. And anything that comes through here, if there were like, I don't know, questions or changes, that would be done on this bill before we reconvened. And I would likely waive amendment deadlines for these as well, considering the speed at which we're trying to proceed here. Does
Thank you,
that
Mr. Chair.
help?
Thank
Okay. Chair, well, we got 5 more minutes. Chair Johnson.
Chair Lesh, Representative Liebling. I always have concerns when we rush bills through because we usually get them wrong. And I want to make sure we get this one right. For those of you who don't know, if I remember correctly, the executive committee is the governor, the lieutenant governor, the secretary of state, and the attorney general. It's the other elected body, not the legislature, which you can give up to a 30-day extension. Representative Liebling, I'd make one suggestion to a change on this, on that 90-day.
Chair Liebling.
We have 30 days from the time, or you have 5 days and the executive committee meets, they extend it to 30. I would suggest that the legislature have to be contacted and get approval for that next 60 days. That would get us involved as well and give the checks and balances and see what it's like after, when we're pushing that 30 days, see what things are going. And then we get involved as well. And it's a good check on the power.
Representative Cantrell.
Thank you, Mr. Chair, and thank you, Chair Liebling, for all of your extremely diligent work on this. Just for clarification, I did just want to say from lines 1.13 to lines 1.21, that is language that is included in statute 144.4199, and that is our public health response contingency account. So this is criteria that exists already in statute. And I think it's a fairly high bar to read. And so I just wanted to put that out there to the committee. I appreciate the conversation. I appreciate your work on this, Chair Liebling. Thank you, Chair Lesh.
Representative O'Neill.
Thank you, Mr. Chair. Thank you, Representative Liebling, for bringing this forward. On the first page, I'm looking at sort of what I would consider the lowest bars of when this is enacted or taken place. And because of what Representative Robbins pointed out about it being a communicable infectious disease, so then I went through the 4 points, and I realized this is already in statute. But if you could just say in front of the committee, help us understand the definition on line 1.20, when it says poses a significant risk of harm to a large number of people. Can you explain what that bar would be, poses a significant risk of harm? If maybe there's a statutory definition of what harm is. I know what bodily harm is. I don't know what in this particular part of statute, what it means as a significant risk of harm.
Chair Liebling.
Well, Thank you, Mr. Chair and Representative O'Neill. I don't know. I mean, this is taken as, thank you, Representative Cantrell. This was taken from existing statute. And again, I don't have the Department of Health here to talk about this. I don't know if Ms. Clarkfist can shed any more light on this. And she's our House researcher who works with the Health Department, and, but, this is existing statute. So Ms. Clarkfist may have an additional comment on that. I don't know.
Ms. Clarkfist.
Mr. Chair and Representative O'Neill, I'm not aware of any other definition or bar in the public health response contingency account language or elsewhere in statute to further define or clarify those terms.
Mr. Chair.
Representative O'Neill.
Thank you, Mr. Chair. So I would, even though it's already in statute, I'd like to know where this has been used before, because to me, that's the lowest bar of the 4 factors. And I think it's incredibly important that we know when this trigger can be made, it can be triggered. So I think it's really important that collectively we as the body understand what those words mean, and we get that on the public record so that we all know what we're talking about. I think it's incredibly important. So again, that's line 1.20, poses a significant risk of harm to a large number of people. To me, that seems to be the lowest bar of the 4 factors, and I want to know when that can be triggered. So if we could get that clarification moving forward.
And I would, I would say, Representative O'Neill, also that significant risk of substantial future harm, which is purely speculative, that's pretty broad as well. I just want to make sure I understand that if there are parallels, which is why I asked Ms. Mullins if there was applicability either by administrative decision or court decision. So I don't know, but I'd just like to kind of know.
Mr. Chair.
Mr. Chair, thank you so much. Like you had pointed out, this is the important work of this committee, and every single word, as you know, matter. And it's the difference between something being triggered or not. So I appreciate you digging even further in to see that as well. But that is the important work of the committee, and we can't really make an informed decision until we know what those words actually mean and what it actually can be enacted.
Sure, and to be clear, what I think, and we'll go to you, Chair Liebling, before we recess, and after that, when we return from recess, we'll have the bill in our possession to which we can apply the amendment, and then we'll go to questions from Barr, Albright, and Scott. I expect that members that we are going to pass this and some version through this body as well, and I suspect everyone's going to vote for it as well, too, just based upon the public health emergency nature of it. I just want to understand it a little bit better. You got the final word before we go to recess.
Thank you, Mr. Chair. And again, I really appreciate the input. We just, this has been done very quickly, as everyone pointed out. And I also appreciate Chair Johnson's comments, which I think are a very good suggestion. We can consider that. We did take this language from the contingency fund, but there is a substantial difference. That involves spending money only. This involves a whole lot of other kinds of powers. So I think you're making a very good point that it may not be appropriate to just simply put all of this into the Emergency Powers Act. So we will certainly think about that. And, I really appreciate that input.
Members, we are going to reconvene at, what time? 15 minutes after floor session adjourns, and it will be in room 200. Committee is in recess.